And here with me today is Oliver Gray. Nice to have you back, Ollie.
Yes, thank you again for having me, Olga.
Just to remind everyone that Oliver is a commercial solicitor and also solicitor dealing with investment and all very relevant issues related to FISMA, therefore, to some extent. But before we start, just as an icebreaker, one of the important skills that is assessed in the SQE, in SQE2 specifically, is ability of aspiring solicitors to negotiate. And this is deemed to be quite important skill. What do you think about the skill and its importance? And maybe you have a few tips for younger colleagues.
I think it's incredibly important because it comes up in everything. To some degree, it comes up in almost everything we do. Even if we're not, for example, negotiating a contract with somebody, even just talking with our clients and interacting with them, there may well be a degree of negotiation over fees or timeframes or a proposed course of action for the future, the way that they're going to handle something and actually process our advice. There will always be a need in some way for negotiation. I think even generally in life, we're going to have to negotiate with people at some point. And for example, it's come up for me a lot recently in probably one of the most literal examples. I am involved in some contract negotiations at my firm with a US lawyer. And some of the tips that I would give to people always are to approach it similar to how people like to approach things like mediation. There's not going to be a winner or a loser. You need to make usually some kind of reasonable concession to find a safe middle ground. You're unlikely to get everything that you want or everything that your client wants, which is something to discuss in advance. And also, if something is really going to be a deal breaker, for example, it needs to be explained why your approach is reasonable. Again, I've had that come up recently with regard to an unlimited indemnity that was requested, which is completely unreasonable in these circumstances. And I had to explain this. And again, a provision with a link to a specific piece of legislation where I tried to remove this and been told, actually, that's a requirement from this legislation, which is a US piece of legislation, actually, that I reviewed in full and said, no, it is not. I think you've made an error there, and we've now removed that. So do some research, make sure the expectations of a client are understood. Be willing to compromise, definitely, because it's unlikely you're going to receive everything that you want, and be reasonable in your approach to it.
Oh, thank you very much. Actually, I would say it's already, it's like a starting point that they have to determine what are their main objectives, like maximum plan and a little bit minimum plan, where they can step back, so it's very important when you go to any negotiations, already have a clue what you exactly want, what possibly your opponents want, and what is this borderline which you shouldn't cross, stepping back, I think. So great, thank you so much.